All right, there is a specific kind of silence that falls over a legal team when they realize the strategy of delay has finally run out of runway. For months, the narrative coming out of the administration was one of total victory. Donald Trump and his inner circle believed they had built a fortress around their new anti-weaponization framework, a wall that no federal judge would dare to climb in this post-2024 landscape. But just moments ago, that sense of invincibility was shattered by a sudden emergency ruling from a federal court that has sent the entire Trump legal operation into a state of absolute frantic chaos. I've been covering stories with stakes this high for long enough to know when a turning point is real, and this is the story the headlines are skipping today. On May 18, 2026, the world learned that the comfortable middle ground has been collapsed by a judge who is officially done deliberating on the limits of executive power U.S. District Judge Kathleen Williams has moved with what legal experts are calling unprecedented speed to halt the president's most ambitious financial and political maneuvers. For a 5-decade empire built on the ability to outlast the clock, this order represents a seismic shift that nobody in the West Wing saw coming this morning. The trigger for this crisis wasn't a long-winded debate or a theoretical risk, but the discovery of active harm being committed through the use of taxpayer dollars. Judge Williams, supported by the sharp legal reasoning of Judge Deborah Boardman, has frozen a massive $1,776 billion fund known as the Truth and Justice Commission. This commission was designed as the crown jewel of the Trump administration's agenda, intended to provide what they called restitution for the victims of past lawfare. But the court saw something else entirely. A structural attempt to bypass the congressional power of the purse to reward political allies and those involved in January 6th. Even more explosive is the court's handling of Trump's personal $10 billion lawsuit against the Internal Revenue Service, a case that had been moving quietly toward a massive settlement. The administration's plan was as bold as it was controversial. Sue the IRS for $10 billion, while simultaneously controlling the very agency that would pay out the settlement. Judge Williams saw right through the strategy, dismissing the lawsuit entirely and labeling the entire maneuver as brazen self-dealing by a sitting president of the United States. This wasn't part of the plan, and you can tell by the way the president's legal team, led by Todd Blanche, is currently scrambling to file emergency appeals. The court ruled that a president cannot legally settle a lawsuit with himself, a basic principle of law that the administration appeared to believe they had successfully transcended. By attempting to oversee the IRS while demanding a multi-billion-dollar payout from it, the president has forced a constitutional clash that is now reaching a fever pitch. This ruling has effectively closed the exit door on a strategy that was meant to funnel taxpayer money directly into Trump-affiliated entities under the guise of legal settlements. The impact of this sudden order is vibrating through every level of the Trump organization, which is now caught between two unforgiving layers of judicial and state oversight, while New York Attorney General Letitia James watches from the sidelines. Calibrating her own enforcement strategy, the federal courts have finally stepped into the breach. The sound of something structural giving way is unmistakable. And it's happening because the judiciary is finally addressing the overlap between Donald Trump, the president, and the businessman. Lenders and insurance underwriters are already reacting, pricing in a new level of uncertainty as they realize the legal environment for the Trump empire can shift between breakfast and lunch. We are watching the quiet accumulation of small decisions suddenly coalesce into a massive wall of resistance that the administration simply cannot drive through. Small vendors and thousands of employees at Trump properties are now facing immediate payment slowdowns as legal teams freeze capital during an intensive federal audit. But the most dangerous part of this ruling isn't just the money. It is the court's appointment of an independent director of compliance to watch every single dollar. This move signals that the court has moved from a defensive posture to an active investigation into the financial architecture of the current administration. As the legal team prepares to rush to the D.C. Circuit, the question remains, how much of this framework can survive when the light of transparency is finally turned on? We have to look at the mechanics of the $1,776 billion Truth and Justice Commission fund. This wasn't just a political slush fund. It was a calculated attempt to bypass Congress. Judge Kathleen Williams moved with unprecedented speed to freeze the entire settlement process because she saw evidence of active financial harm occurring right now. The court discovered what it termed active harm rather than a theoretical risk. This is the moment the anti-weaponization framework hit a brick wall. At the center of this freeze is the appointment of an independent director of compliance. This individual now holds the keys to the kingdom's financial oversight. Their mandate is simple but devastating. Ensure that not a single taxpayer dollar is diverted to Trump-affiliated entities or family members. This oversight is now absolute and immediate. This new federal layer of scrutiny is happening, while the Trump organization is already gasping for air. It is caught in a pincer move between state and federal authorities. In New York, Attorney General Letitia James is watching these federal developments with clinical precision. She is calibrating her multi-layered enforcement strategy in real time. James is focused on the $450 million civil fraud judgment that still hangs over the president's empire. She is looking for any sign of federal funds being used for personal debts. If those $1.776 billion funds touch a personal debt, James has indicated she is ready to seize assets immediately. The comfortable middle ground has been collapsed. This is why the strategy of delay just ran out of runway. There is no more time to push these critical dates into the distant future. Lenders and insurance underwriters are watching this play out with growing alarm. They have already begun pricing in uncertainty for any business connected to the Trump name. Between breakfast and lunch, the legal environment for the Trump organization shifts so rapidly that lenders are pulling back from their previous multi-million-dollar financial commitments without any advanced warning. Then there is the matter of the $10 billion lawsuit against the IRS. The court labeled the attempt to settle this while overseeing the agency as brazen self-dealing. You cannot legally settle a massive lawsuit with yourself. That was the exit closing the court used to shut down the maneuver in its tracks absolutely immediately. This wasn't part of the plan. The administration thought the executive branch's power over the IRS would provide a clean exit from a massive liability. Instead, they found a judiciary that is done deliberating. Judge Deborah Boardman's supporting rulings have reinforced this massive wall of judicial resistance against the executive branch. The independent director of compliance isn't just a monitor. They are a roadblock. They represent the first real structural judicial block to the new administration's agenda. This is where the technical details get truly ominous for the inner circle. The court is now looking into the quiet accumulation of small decisions made within the commission. Every grant and every payment is being audited to see if it rewards political allies or January 6th defendants. The power of the purse is being reclaimed. Barbara Jones, the independent monitor who has seen it all, is also preparing a new report. This one focuses specifically on overseas business partners and transparency. If that report shows a lack of transparency, it could trigger further federal restrictions. The walls are not just closing in. They are becoming far more technical. This technical oversight is exhausting the organization's staff. Small vendors and employees are already reporting payment slowdowns as capital remains frozen during these audits. The human dimension here is a chaotic scramble that suggests a terrified inner circle. Low-level employees are caught in the machinery of a major constitutional clash. The anti-weaponization framework was supposed to be the shield. Instead, it has become the thing triggering an active federal investigation into the administration's financial architecture. We are seeing the sound of something structural finally giving way. The judiciary is at last addressing the overlap between Donald Trump, the president, and the businessmen. Every legal constraint is now being turned into campaign material for fundraising. But in the courtroom, those talking points carry zero weight against an order. The upcoming 60-day window is a final countdown for this team. They are preparing emergency appeals even as the monitor watches every single penny moving through the commission. Beyond the high-stakes legal motions and complex filings, the real human cost is beginning to surface now. Small vendors who provide services to the Trump organization are reporting significant payment slowdowns as capital freezes fast. As legal teams audit every transaction, these local businesses are being squeezed by a process they never asked for. It is the distinct sound of a massive financial engine grinding to a total halt today. Thousands of staff members at various properties are now caught in this machinery of uncertainty. When capital is locked, the ripple effect doesn't just hit the boardroom. It hits the ground floor workers first today. This isn't just about balance sheets. It's about the people who keep the lights on and doors open. They are the ones feeling the immediate weight of Judge Williams' sudden and unprecedented emergency ruling tonight. The chaos extends deep into the federal government, reaching the very people who carry out American policy. This order coincides with a total freeze on federal grants that has left several agencies completely paralyzed right now. We are seeing the shuttering of USAID workers who were already pulled from the field under executive orders. Now they face a future with no clear funding, no instructions, and no path forward today, actually. These field workers are in a state of absolute panic as they wait for clarity that isn't coming. The anti-weaponization framework has effectively frozen the tools of international aid across the globe this week now. This is the human dimension of a constitutional crisis that many saw coming but few prepared for. It is what happens when the machinery of state is shattered by a single federal court order today. Meanwhile, New York Attorney General Letitia James is watching these developments with a predatory focus. She is already calibrating her enforcement strategy regarding that $450 million civil fraud verdict right now. James is reportedly looking for any sign that federal funds are being used to pay personal debts. If that happens, she is prepared to move on asset seizures against the Trump Organization immediately tomorrow afternoon. The prospect of losing the crown jewels of the empire is no longer a theoretical threat to Trump. It is a live contingency that depends entirely on the next few hours of high-stakes judicial review. To prevent this, the court has installed an independent director of compliance to monitor every single dollar. Their job is to ensure taxpayer money is not diverted to Trump-affiliated entities or any family members now. Every financial move the administration makes is now under a microscope that they cannot easily shake off. The era of unchecked executive spending on personal litigation has hit a reinforced wall of judicial oversight today. We are looking at a 60-day window that will determine the structural integrity of the American presidency. Trump's legal team is expected to file emergency appeals to the D.C. Circuit within 48 hours from now. They will likely push this to the Supreme Court, seeking an immediate stay on the judicial order. They are fighting to regain control over the $1.776 billion federal commission fund immediately. But time is not on their side as the legal calendar fills with new and dangerous threats. Independent monitor Barbara Jones is scheduled to release a new report that could be even more damaging tonight. That report focuses on the Trump Organization's transparency regarding overseas business partners and hidden accounts. It is a thread that, if pulled, could unravel years of carefully constructed and guarded financial secrecy tonight. The strategy of delay just ran out of runway after 5 decades of successful stalling by Trump. For years, this empire has survived by outlasting the clock, but the clock has finally caught up tonight. This is the beginning of the end of uncertainty regarding the control of taxpayer money in America. The comfortable middle ground has been collapsed by a judge who is done with deliberating on theories today. Watch the quiet accumulation of small decisions over the next few weeks as they slowly pile up. They will tell you more about the future than any televised campaign rally ever possibly could today. Subscribe to Maddow's Newsroom now to stay ahead of the scramble that is happening behind closed doors. We are witnessing the final blow to a strategy of total immunity and unchecked executive power tonight. This is Maddow's Newsroom. We will see you when the next federal order finally drops.